here, volunteering your lunch hour and a little bit more to talk with us about the Justice and Municipal Court Appellate Project. I'm connected to this project because, like Krista Obel-Eshelman, who is the co-chair of our work group, we are members of the Oregon Law Commission. We're commissioners, and this is one of our law improvement projects. So that's my connection to it. What we will do right now is just go around and I'll have Krista introduce herself. We'll also introduce Sandy, who is and Sandy will explain his position. Sandy is the director of the Oregon Law Commission, but he is filling multiple jobs right now, and he'll explain that to you. And then we'd love to have all of you introduce yourselves, explain your connection to justice or municipal courts or appeals, whatever it is, so that we all get to know each other at the outset. And then we'll talk about our process going forward. This meeting is scheduled to go through 1:30. We will end at 1:30, and we really do appreciate all of your time. Several of you have been involved leading up to this meeting and have provided feedback on our drafts. And we greatly appreciate that and look forward to getting more feedback on the drafts and benefiting from your expertise, especially those of you who are on the ground in the justice and municipal courts as judges, justices of the peace, and practitioners. So Krista, why don't you introduce yourself, and then I'll have you take the role of calling on others to introduce themselves.
Hi, I'm Krista Obel-Eshelman. You've probably seen emails from me. I'm co-chairing with Justice Duncan, and I practice juvenile appellate law and don't have any connection to justice and municipal courts other than being co-chair of this. So I really appreciate the expertise that you all are providing here. I'll call, well, Sandy, I guess go ahead and introduce yourself.
Thank you. My name is Sandy Weintraub. I have been the director of the Oregon Law Commission now for many years, though the last few as an interim. And at this point, I'm a very small percentage of an interim because I have other roles at the University of Oregon. We're working to find a replacement, but I am here to assist with the administration of this committee right now. If you have any questions about it until you've heard there is a new person in the role, please feel free to come to me. And thank you all for joining or continuing if you're on this group. It's a project that has a lot of commitment from the OLC, and we're really excited to move forward. Thank you.
Jim Nass.
My name is Jim Nass. I am Court of Appeals Appellate Commissioner, retired now for about 3 years. I worked for the Court of Appeals for about 30 years in various roles. In the course of that time, in wrestling with appeals from justice and particularly municipal courts, I became aware that the statutory framework for municipal court cases was extremely complicated. And so a number of years ago, I think about almost 8 years ago, I wrote to the commission suggesting that it convene a work group to consider revising the statutes governing appeals from justice and municipal courts, just to clarify them and make them much more useful, particularly for pro se parties. Because that's mostly what I dealt with, was pro se appellants who were coming to the Court of Appeals and trying to understand the statutory scheme. So my only connection with a municipal court is I appeared on a traffic ticket one time. Yeah, I have no other connection with a justice or municipal court. My role is largely just analyzing the statutes and trying to figure out a way to simplify them.
And Jim has really been instrumental in getting this group started and moving it forward. Lindsay?
Good afternoon, everyone. My name is Lindsay Detweiler. I'm an attorney in the Office of General Counsel at the Judicial Department. And so I work with circuit courts, and I'm here representing just the state courts on this work group.
Jimmy Brewer?
I'm Jimmy Brewer. I'm an attorney for OPDS. I handle criminal appeals in the Court of Appeals perhaps a small percentage of which originate from municipal justice courts, but mostly I don't have much contact with them.
Jordan Hooper.
Hi, I'm Jordan Hooper. I've been a public defender for a bunch of years, currently with the Office of Public Defense Services, although I was instructed to say I'm here under my personal capacity and not representing the agency. My experience with municipal and justice courts is I spent a lot of time practicing in them when I was first starting out my practice at a private practice in Eugene. So I spent a lot of time in the Eugene and Springfield municipal courts.
Melissa France.
Hi there, everyone. I'm a returning member to this work group. I'm a practicing assistant city prosecutor in the Eugene Municipal Court. And I used to work for the judicial department once upon a time. That's when and Lindsay, it's good to see you. I haven't seen you in years. And at that time, we worked on the direct criminal appeals work group back in 2017 when we were sort of modifying a bunch of things. So now bringing that, what little of it I can bring the expertise to this work group, I'm happy to be here.
Justin Kidd.
Hey there, my name's Justin Kidd. I'm a relatively new Justice of the Peace. I've been on the bench for about 2 years. I'm really excited about Justice of the Peace work because we had a lot of pro se work, and that's just really where my heart is. In the right hands, Justice of the Peace is, justice courts are an amazing tool to promote access of justice and also lift the burden on the circuit court. So that's really my interest here.
Greg Gill.
Hi, my name is Greg Gill. I'm the presiding judge for the Eugene Municipal Court. Been presiding judge since 2019, pro tem before that. And the city of Eugene, as Ms. Franz knows, has a lot of cases that come through it, both misdemeanor as well as violation. And so we deal a lot with things that are set up to appeal. And we've seen a lot of the scenarios that I think this group has looked at and will continue to look at. So it's going to be really important to be a part of the process. Thanks.
Patrick, I'm sorry, I don't know how to pronounce your last name.
That's right. Patrick Singh. I think I might be the only non-attorney here. I'm a pretend lawyer at the Capitol as a lobbyist, represent both the muni courts and also the justice courts for about the last 3-4 years or so as a contract lobbyist. And then prior to that, I worked at Association of Oregon Counties on public safety issues. So I worked with the justice courts then for about 8 years. And I'll primarily be just kind of sitting and listening in the background. The Patrick's Autopilot, that's also on the list. That's my automated note-taking tool that joins all my meetings, so you can ignore that one too.
Juliet Britton.
Good afternoon. I'm Juliet Britton. I am the presiding judge at Beaverton Municipal Court, but I'm here today in my capacity as the Oregon Municipal Judge Association president. We have membership that includes justices of the peace, most justices actually of the peace in the state, and tribal judges, circuit judges, mostly referees, as well as municipal judges. So happy to be here. I started my career 25 years ago in the legislature, drafting legislation. So this brings me home full circle.
Heather, is it Merrick?
Merrick.
Merrick.
Hey, everybody. I'm Heather Merrick. I'm a staff attorney with the Lane County Legal Aid Office of Oregon Law Center. We're a civil legal services organization for low-income folks around the state. And so our attorneys appear from time to time in justice court, particularly around FED matters, and then also the municipal court representing individuals for non-criminal violations. So sometimes those cases are appealed, and so we've tried to help folks navigate that process and are really eager to to continue the discussion with you about it.
Jessica?
Hi, everyone. I work at Legislative Council, and I will eventually be taking the draft that we come up with here and turning it into a bill for hopefully the 2024 session.
And there is someone on my screen who just says judge, so I'm not sure who you are.
I need to fix that. I am Chris Patnode. I am the Gillum County, Oregon Justice of the Peace. I am also the president of the Oregon Justice of the Peace Association. I've been on the bench for 21 years. I'm a non-attorney judge, and I appreciate having the opportunity to be a part of this. I believe the rural voice of Oregon needs to have a voice, and I appreciate that we get to be a part of this. I also want to say that although we're in rural Eastern Oregon, Interstate 84, between the Dalles and Pendleton, if you're going to Idaho, you're going to go through Gillum County, and we have a lot of activity on the freeway. So although it's rural, there's a lot that goes on in this little tiny court. So thank you for letting us be a part of this.
And the last person I see is Patrick's autopilot.
That's my kind of automated note-taking tool.
Oh, okay,
so
gotcha.
Ignore that. Yep.
All right. Did I miss anyone? Thank you all for being here.
Great. It is wonderful to meet all of you and have you join us in this effort. I think just hearing everyone's descriptions of what they do, I think we have a great group of people with really valuable expertise and insights, and who can explain how things work on the ground and have suggestions for how things can be improved. So thank you all for being here. I'm going to tell you a little bit about how this project came to be just for a few moments, and then we'll talk about our draft, and we'll dive into our process of soliciting feedback. So as a couple of you have noted, this project, which is the Oregon Law Commission project, grew out of an earlier one. Jim explained how a few years ago, several years ago now, there was a project to update the statutes which are in ORS 138 that concern appeals in criminal cases from your circuit courts to the Court of Appeals generally. And so in that work group, they updated the statutes, the bill was passed, but as they were working on it, they recognized that there was work to be done with respect to appeals from justice and municipal courts to the circuit courts, and then from the circuit courts to the Court of Appeals. But that group needed to have a different membership, a membership like the folks that we have here, to take on the justice and municipal court specific issues. So that's the idea behind our group. Our task, which because of the kind of complicated and widespread statutes that involve justice and municipal courts, our task is narrow. It's just about how do we make it as easy and clear for people to bring appeals from the justice and municipal courts to the next step. How do we improve the statutes? Some of the statutes have antiquated wording. Many of them, as I said, they're spread across several ORS chapters, and there's a lot of cross-references. So our task is just to simplify that. But as you have seen in the email traffic over the last couple of days, that task in explaining how you bring an appeal can be complicated because of a lack of clarity in some other statutes. And we run right into that in our draft in the first section where we talk about what's the jurisdiction of a justice court. So some of these things that are related to our pretty discrete task might implicate broader areas of governance with the justice and municipal courts. We want to be really careful about that. But our particular charge is just to improve the process for moving cases from what, just for ease of reference, I'll call the local courts to the circuit courts. So that's our task. As you know, as people who've worked in these with these statutes, one of the things that makes the appeal process complicated is there are a lot of cross-references. So if you are in a municipal court, and you're trying to figure out how to appeal something, the municipal court statutes might reference the justice court statutes, which then in turn might reference either chapter 19, which concerns civil appeals from circuit courts to appellate courts, or chapter 138, which is criminal cases that go from circuit court to appellate court. So there's a bunch of cross references that can be very confusing. And one of the things that this group will decide is, what can we do about that? Can we create a hopefully like a single process for bringing appeals from the local courts to the circuit courts, or a process for justice courts that's very similar to one that's for municipal courts? Do we set them out in separate chapters? How can we make this as easy as possible? So there's organizational questions. And then, as you will be familiar with, there's some questions about how the process actually works with the statutes. We know where the notices of appeal are supposed to be served, but which court decides whether a judgment should be stayed? Which court decides whether a fee waiver should be granted? When does that happen? Who transfers the record from one court to another? Those are the process things that our objective is to make clear and simple. So those are our big picture goals. And to tell you about where we are in terms of our drafting, we owe a great debt to Jim Ness and Jessica Menifee, who have created our working draft. Jim went through all of the chapters that govern these appeal processes and created a draft, which our smaller group of us then worked and got feedback on. And then the draft that you got was our third draft. And it intentionally concerns only the justice courts, because like I was saying, if we can come up with a process that works for justice courts, our next question will be, can we use that same process or something very, very similar for municipal courts? So that's, we have our working draft. What you should understand about the draft is that it is a starting point for discussion. We think that there are things that we just say, this is a proposal. Do not feel like anything that is in the draft is written in stone. You are experts. We want your opinion. We want your suggestions. So that's what we're going to try and do over the meetings that we have with you. We would like to, the Law Commission would like to have a bill that we can introduce in the short session. That is the session that will be in January, beginning in January of 2024. That may seem like a little ways off. It's really not, because it's Jessica will let us know if we want to have a bill introduced. We're talking about having something close to a final project by early in the fall, end of October, probably, right, Jessica?
Yeah, and there is a little bit of flexibility there if you wanted to, for example, introduce something that was almost final. That would need to be sooner rather than later, but there is a possibility for introducing what's known as a placeholder, which is basically a study or something similar, which could then be amended to contain the substance of this draft. That might not be favored because you might want to give people notice about what's coming here, but that's something that the work group could discuss in the future.
So just to give you an idea about our timeline, that's what we're hoping to do. And that may affect kind of how tightly we control the scope of this project. I know, Justice Kidd, you've raised other issues about the equal protection issues and jurisdictional issues for justice courts. Whether there's a couple of things we would have to decide as a group about whether we could even take that on, but we do have kind of time pressures. And if we have a narrow scope and we are concerned with appeals, it may be that we do a bill that covers that. And then maybe this group continues and we continue to talk about those other broader issues and make sure that all the stakeholders for concerned about those issues are present too. So that's our scope, our task from the Law Commission. And your role is to provide us feedback. And we're trying to have multiple ways where you can do it. We'll have these meetings. We will provide you with drafts with questions in them, which you've already received. We have utilized shared documents that Sandy can create where when you have the time and can work through the draft, there'll be a place for you to put comments or annotations. So we want to get your feedback in a variety of forms, whatever works best for you. So Any questions about that?
I just had one, Justice. It was, I thought the short session was going to be very limited just to a couple of things. And I have to confess, I was not anticipating that we were going to try and get this into the short session. And even if we had something set up, I was not under the impression that they were going to be entertaining much beyond that scope. Am I wrong? Am I missing something?
I also wondered about the scope of this shared session. Jessica and I talked about that, and I'll have Jessica explain. I'll let Jessica explain that it is a possibility that we can have something like this, especially if we know that it has support, broad support, that this is something that the legislature could take up in a short session, which is different than perhaps how I had conceived of the topics for short sessions in the past. But Jessica?
Right. And there's no hard limits on what can be tackled during the short session other than really political limits. The one kind of caveat is that the members and the committees have bill draft limits. They each get 2. But as long as you have a member or a committee that's willing to sponsor this, then it's definitely a possibility. There's nothing preventing this from going forward during the short session.
And I know there's nothing that would prevent it. It's just my understanding conceptually was that there was kind of limited, and that may come from a different conversation I had with Patrick Singh. I could be wrong, but that's what I thought was they were going to. It was their intent and goal was to have a rather limited, very small focused session.
And I think we can go with the goal of having this in the short session. And if we have a narrow focus and it's there are procedural changes that we're putting forward, maybe that's something that they would, that the legislature would take up in the short session. And that would be great. If it doesn't fit, if we need to introduce it in the long session, that's great. We have this project underway and would love to keep, taking the steps towards however we can make the improvements in the statutes. And then before we dive into the draft, I'd just like to say, like I said, nothing here is written in stone. We want your input. We're interested in the pros and cons of what's in the draft. And so we would like you to offer those. It's great if you identify a problem, if you can also suggest a solution or alternative language that you would think would be better. That would be great. It's not required, but that's helpful. Also, a word about formality. We want to have a conversation among this group. We're not going to be adhering to, rigid rules with respect to, we're not following Robert's Rules of Order. This is a discussion. We're soliciting input. We won't be having any motions or votes. We want to hear what you have to say. And after this meeting, to the extent that there's feedback that we've got, we will summarize that and send it back to you. So today, especially, we are not, taking any votes. You don't need to engage in a debate. Just point out, areas that we need to pay attention to and possible solutions to any problems. We value your thoughts and your time. So we will try, please, if you have suggestions, make them as specific and as focused as you can. Don't feel like this is the only conversation we're having on these issues today. We know some of our members can't be here, so there'll be the opportunity for feedback in writing if you need to do that. If you need to take something back to your group, that's all possible. As you saw from the notice that Sandy put up, these meetings are being recorded too, so that members who are able to be here online live can see what people shared later on. So that's what we're doing today. You do have the draft. I don't know if I'll give you a moment to call it up because we're ready to dive right into it, and we'll just continue going in order of the sections in the draft. We'll spend the amount of time that we need on each one. If it looks like something needs additional research and somebody to come back, we will ask that. We will ask for that. Krista or Sandy, if it gets to the point where we're like, okay, that's something that we need a volunteer to go research and report back on, can you just keep a running list, and about 10 minutes before we're done, 5 or 10 minutes before we're done, we'll have those lists of things that we will need volunteers for, and then we can call out for volunteers at that point. So you don't have to sign up right away, but there'll probably be opportunities for people to go gather some more information. So any questions? No, great. Okay. And I have been on meetings where people have said you do have to give a little bit more time for people on the screen to unmute and pipe up. So I will entertain some awkward silences while I make sure you all have a chance to do that. So let's dive into the draft. And section 1 of it concerns the jurisdiction of justice courts. And what this draft does is talk about jurisdiction over offenses in section 1, and then jurisdiction over civil actions in section 2. And as you know from the emails that have been circulated between Justice Kidd and James Neff, there's questions about the jurisdiction of justice courts and whether the existing statutes, which this draft just reflects, it doesn't mean to change any of the jurisdiction of the justice courts. But because it reflects the current statutes, it reflects, as Justice Kidd said, kind of a spaghetti of statutes, and maybe it's not as clear or possibly correct as it needs to be. So I'll maybe turn it over here to Jim and Justice Kidd and have you share with the group thoughts on what this draft should do or could do with respect to the jurisdiction of justice courts. And then this does seem like something that we may have a follow-up memo and proposal on. And I would say, you know, our task is just how do we describe the appellate process, but the existing statutes talk about what the process is for different types of cases. And so when we're talking about different types of cases, we need to, that is related to what types of cases can even be in these courts, which is why the section leads off with a description of jurisdiction. So Jim and Justice Kidd, do you want to just share with the group orally kind of a summary of what you've put in your emails and any thoughts on these first 2 sections?
Yes, I can start off with that. One of the things that has bothered me about section 1, subsection 1A, which is a restatement of existing ORS 51.050 sub 1, is this clause, is this introductory clause, in addition to the criminal jurisdiction of justice courts already conferred upon and exercised by them, close quote. I don't know, and I haven't been able to figure out to what that refers. What other statutes confer criminal jurisdiction on justice courts? My second concern is this reference to exercised by, as if exercising jurisdiction somehow confers jurisdiction. That seems to me to put the cart before the horse, or the cart before, yeah, because first you have to have statutory jurisdiction before you can exercise it. Thirdly, just from a drafting point of view, it seems odd to me that there's this reference to criminal jurisdiction and then you take out of it all felonies. Why not just say misdemeanors? And then lastly, second to lastly, there's this reference in 1B as to when a crime is triable in the justice courts. And what I finally figured out is that ORS 131.205 to 131.325 and another statute in the chapter on the violations actually talk about what we normally think of as venue issues, where an action can be filed. Because justice courts have geographic limits on them, what these statutes do is, for instance, if one element of a crime was committed in one county and another element committed in another county, or the effect of the crime took place in some other county, that action can be brought in either county. So it could be brought in either justice court. And then secondly, the statute in the violation chapter says if someone commits a violation in a place that is closer to the county seat of another county than the county in which the justice court is located, you can be cited into that justice court. For instance, here in Salem, West Salem is part of the city of Salem, but it's located in Polk County. If a person commits a violation in West Salem that could be cited into justice court, the person could be cited into the Marion County Justice Court rather than a Polk County Justice Court. So it took me a while to figure all that out. And I think the statute could do a little bit better job of spelling out what that means. And the last thing is this reference to concurrent jurisdiction with municipal courts. I don't think there is any such thing. The statute itself says justice courts don't have jurisdiction of any offense created by city charter or ordinance. A justice court can exercise jurisdiction over municipal statutes if they have this agreement under ORS 51.037. But in my view, that's jurisdiction in lieu of, not concurrent with. Those are my thoughts.
Yeah. So if I can just briefly add, right, and I bow down before all of you who like practice appellate law and get like and draft this in like really useful ways. I'm just a humble practitioner, but my sense is, after reading our spaghetti of statutes, as I said before, is that we have a whole bunch of unintentional drafting errors that make things like create little like weird loopholes. And I think what the legislature actually intended was just basic concurrent jurisdiction for the justice courts with part of what the circuits courts do, things that are not felonies. So and Justice Duncan, I think that email that was between a smaller group of us, I don't think it's been shared with the wider group. So we should probably do that because it was still a little bit conceptual. But my basic proposal is just like we should just say what we mean, right? And so I think that there's a way that we can say what we think the legislature intended to do that doesn't involve referencing 9 other statutes, because for pro se people, the people who I see every day, that is, it's a mess, right? It's really hard for them. And so that's my, that was my 2 cents.
Yes, that is consistent with our overall goal, which is to try and make this as simple as possible for the litigants and the courts, the local courts. Are there other reactions to these 2 sections on justice court jurisdiction?
Well, I think the warrant, I mean, the concurrent jurisdiction language is because if you have a traffic violation, for example, committed in a municipality, the citing officer could file that in the municipal court or in the justice court, for example. So there's that. I mean, that's why I think that language exists there, is to make that make sure that that's clear. With regard to some of the language in terms of I admit it's confusing in 51051. In addition to criminal jurisdiction, established. I believe that might refer to. Am I not mistaken, or if I believe a justice of the peace can actually issue warrants in all sorts of cases, even though we can't actually hear those cases. Those don't come to me. The DA's office in Washington County doesn't want to bring warrant requests to me, and I'm fine with that. I don't need a 3 a.m. phone call. But the fact of the matter is, I think that, Jim, that might be what, for at least one example of what that might be referencing, is for some of these powers that exist in the criminal arena, but outside what the justice court is permitted to hear at trial. Those are at least my couple of quick thoughts.
Okay. And Heather, I'm seeing a comment.
I think Juliet had helpfully added the language I talked about this morning, and I think Jim has iterated even a little bit more on that. But that's, I think the group should look at it.
Okay.
It's simple. I like simple.
Okay.
Justice Duncan, how about if we do this? How about if the Justice of the Peace and municipal judges and I continue to work this over a little bit, and maybe by the next meeting we can come back with an agreed upon set of words that will make everybody happy.
Yes, I think that would be great, Jim. Thank you for taking that on. And if folks want to do the research and propose some language for the jurisdiction of the justice courts, that would be great. I think the questions we would want to answer is, what are the existing statutes? Why do they have these limits, or at least these perceived limits? And is there any, whatever the limits are, what's the policy reasons behind them, if any? And perhaps they're just drafting errors, but if there are policy reasons behind them, like this, no jurisdiction with, if your county seat is of a certain size, what are the policy reasons behind those, and why we're going to say that those changes, those limits should no longer exist? Why are those policy reasons no longer appropriate? Or so that would be great. So Jim will take you up on your offer and have you circle back. Why don't you can send an email to the group, and then anyone who wants to participate in working on sections 1 and 2, the jurisdiction, you just reply to Jim, and then he'll work with that subgroup on these 2 sections. Does that sound okay with everyone? Okay, great.
That works for me. And I just want to add that I still have a line of communication, as I've been on the bench for 21 years, with some old justice of the peace that may understand some of the basis for some of this that were there when some of these were created. So I can tap some of that knowledge.
That would be hugely helpful, because we don't want to step into some proposed change and not know why something that we proposed undoing was done in the first place. Okay.
Justice Duncan?
Yes.
Could you or Sandy or someone distribute an updated version of our membership list along with contact information? It'll make it easier to figure out who we should be sending emails to.
Yes, we'll have Krista and Sandy coordinate on that. And I would just call out that I know Melissa was added back onto the list, and then Justice Kidd also was added onto the list. So we'll just double check to make sure we have those. All right. So if we put sections 1 and sections 2 with that group, that takes us to section 3, which is the case record. And in our drafting group, one of the changes that we made concerned the transfer of the case record. Section 3 is intended to make it clear that the Justice Court is responsible for transferring the record from the Justice Court to the Circuit Court. Previously, it appeared that the litigant themselves was responsible for that transfer. So let's just take a moment and get this group's sense on the capacity of having the Justice Courts transfer the record. Actually, I might be getting ahead of myself, because this section is just describing. This section is just describing the record. Sorry, I'm getting ahead of myself. So the purpose of section 3 was to clean up some antiquated language. One of the things that the statute used to talk about was the transcript of a case, and these are from courts that are not of record, so there is no transcript. But what was meant by transcript was what we would call now the register. So section 3 describes borrowing language from circuit court statutes. Here's what a case register is. Basically, it's like your log of events. And then here is the case file, which is all of the documents that have come in. So for those of you in the courts, does section 3 work for you? Is this a description that comports with your current practice, or could be something that the courts could do? It's pretty much just describing, here's the log, here's the file, and it's labeling both of those things as the case record. And then later on in the bill, it says the local court transfers the case record.
Do you want to specify what happens to the exhibits? Because I give my exhibits back to them like you do in circuit court, and then people sometimes like trash their exhibits.
Okay.
Right? So if we're thinking about what pro se people might want to do, you might want to have that rule.
And I know even in circuit courts, there can be some variation on how long the exhibits are retained before an appeal is brought. So maybe we can look at the circuit court practices and see if those circuit court practices would work in justice court. I think just off the top of my head, I wonder if there's value in having the justice court retain the exhibits for the appellate, the notice of appeal time.
The
so
hard part about
what
that,
you're talking about doesn't happen, but that would create a burden on your courts. What do people
It would, and you know, I was thinking back, it's been 7 years since I tried a case in a circuit court, but I know they were given back the exhibits at the conclusion of the trial in circuit court back then.
Okay.
I guess the better question would be is because in my court we don't log the exhibits. You know, if we don't create a record of like they would in the circuit court of exhibits that were received and evidence in the case.
Okay.
Does any other Judge Kidd, do you do that in your court?
I do in civil. I do in civil. In you know, in violations, we do like 20,000 violations a year, so I couldn't do that really. But and so maybe I'm creating a problem that doesn't need to exist. I have had civil people, I gave them back their exhibits and they threw them away, and then they were like, "Well, what do I do about that?" So
what I do is I give an explanation at the conclusion of the trial. You know, I give an explanation of the appellate rights, and I include with them the fact that if they intend to appeal, that the parties should retain their exhibits in the event that there is an appeal, and put the burden on them, if you will.
Okay.
I think that's sufficient under current statutes, but Justice Duncan may at some point in my life tell me I'm wrong about that.
Justice, I can chime in to answer the circuit court question. At least when I was practicing in Lane County Circuit Court, they had us sign for the exhibits for cases, and then we'd retain them in the event of an appeal. But the lawyers in that case would retain them, and we could do that almost immediately after the trial was concluded. In fact, we were encouraged to do that as soon as we could get over to the court to do it, because they didn't want to hold on to it either.
Okay. So justice court folks, how, if you have an exhibit that comes in, does it just go right back? How would it work if people had to sign for them, if you had to store them?
Storing them would be a problem in my court. Having essentially again, my recollection from years ago in the circuit court, there was a log, you know, an exhibit, and then at the end of the trial, they were returned to the parties, and yeah, we signed the form indicating we'd received these exhibits back, and there was, I believe there was language on there to the effect that you should retain them for purposes of an appeal if an appeal is timely filed or something like that. I'm not, don't hold me to the exact verbiage. But yeah, they put the onus on the litigant to, or litigant's counsel to retain the exhibits in that eventuality. And I think that makes perfect sense. I think that we could have a form like that we could develop, you know, pretty darn quick, because we could essentially steal it from the circuit court anyway.
Is that would that be an administrative challenge for other courts?
Due to our size, no, not for us, but I know it may be for others.
Okay. And one thing to find with the exhibits is the appeal in most of these cases is going to be at the conclusion of the proceeding, and then you're going to have a de novo trial in the circuit court, so there may be limited need for the exhibits at all.
I think I just made up sorry to interrupt. I think I made up a problem that doesn't exist. So I don't want to send us down a rabbit hole about that. I apologize.
Now you could have an interlocutory appeal. Maybe but even it's de novo. Okay, so we will think about exhibits and then maybe propose some resolution which could include not mentioning them in the statute. I saw 2 hands come up, but then go down. Everybody's.
I was just going to make the point that insofar as it's a de novo appeal, I don't think the circuit court needs the exhibits from the justice court. The party can take the exhibit back and then introduce them again in the circuit court.
Okay. So on the next draft, we'll probably have some sort of explanation about why that is or isn't addressed.
Well, and can I just jump in really quick? Because this is going to be relevant throughout, I think, our discussions, especially when it has to do with uniform forms throughout the state, and then who pays who, and then when is it stayed. Here you have just that first contact that a pro se or anybody would have with the court. And we like to have as much communication and information as possible. So right there, if they're going to get the appeal rights, but with someone has a resolved case one way or the other and they want to appeal it, they're going to get a lot of information anyway. And part of that information is going to be, if you decide to appeal, even if you don't know, keep all of your exhibits so you have the ability to do that. So that's part of the communication piece up front. So folks that come through these courts can be as informed as possible as they move through.
Mm-hmm. Definitely. And we know OJD has some expertise in developing forms. We will talk about where the notice of appeal is filed, but when we think about these types of things, if we want uniformity across the state, we might think about what's the circuit court's role, because the circuit courts will be working with OJD and they may have the ability to establish more uniform forms and procedures. So that's something to keep in mind. Some of the questions that we have in the margins of the draft are minor, but but they're unresolved. So one of those questions is about section 3, and it talks about the case register, and this is just taking language from existing statute, should include a record of any undertaking and a justification of a surety. And we just didn't know whether we needed that language, justification of a surety, because we didn't know if that was a filing that would be in the case record or whether we need that here. I don't know if anyone has an opinion.
Justice Duncan, I can tell you that the practice in circuit court is that most undertakings today are either cash bonds or occasionally a commercial bond. Very rarely do you have justification, that is, other citizens who are willing to pledge their resources and assets. And in any event, that, in my view, that's part of the undertaking. So I think we could probably strike everything after undertaking, because if someone does object, I think they would have the right to do so even without that wording.
Okay.
Here's a question, right? So the people in my court do not know what an undertaking is, right? So if we're trying to make this accessible, is there a different word that we could use that means the same thing?
Yes, I think when we get to the civil section, we need to take a careful look at how we describe basically the undertaking process. And if we can revise that, that would be very helpful. Yeah. So in my practice was entirely in criminal law, so I've never filed an undertaking, and I'm in a similar position as Jordan. So hopefully we have
that makes me feel better. Thank you, Justice.
Hopefully have some folks who can help us out on that. We may need to reach out for some help on that one.
I wonder if we worded it as any undertaking in support of a stay, so that readers would at least understand that what we're talking about here is stays.
Yeah.
But
And
I
it
don't know
may,
if that's any more helpful to pro se's, but
I think
at least it gives you a little, at least some hint of what an undertaking is.
so I think we can make a note that we should return to this description in H when we revise the undertaking portions of the rest of the statute, and then just marry this reference back up with whatever we end up in the undertaking statute, if that sounds okay. The last thing that I just ask about is an addition, which is subsection 4, and it says that the Justice Court may maintain its register of case files or both in electronic form. That's a new provision. We've taken it from an existing statute for from ORS 7095. Any reactions, thoughts, concerns about that?
I concur.
Okay. Let's move over to section 4. This talks about, yeah.
Just a second. I have two things.
Yes.
In 2C, the statute would require that the register contain the time when the parties or either of them appears or their failure to do so. Do justice courts keep track of default dates and note in the register when a party has defaulted, or do they rely on the parties to keep track of that?
Date, yes. Time, no.
What did you say, Judge?
I said date, yes. I know the date. I don't keep track of the time.
Same with me.
Oh, you mean like the time of day?
Yeah, that's what I said.
Yeah, we don't. None of my file, the filing stamp doesn't have the time on it. Which is interesting because just this morning I was hearing where a default judgment was filed in a small claims case. I signed the default judgment because it was day 15, so 14 days had passed. Then later that same day, the answer rolled in and hit my desk a later time. I can't tell you. I know because the answer that was sent in was sent by express mail or the post office. I know what time we received it. It was 12:37 p.m. But I don't know what time I saw the default judgment motion and signed that. Looking back at it, I still set aside the default judgment on the basis that these appellate courts higher than me, they have this notion that the cases should be decided on the merits. So I relied upon that line of rationale and set aside the default. But it would have been an issue I could not have resolved if I had to know the time. And that's something my small claims clerk and I were just talking about this morning, was whether or not we should get some kind of a timestamp. But I don't know. But I think most justice courts are like myself and Judge Kidd don't have the times noted like that. I don't know. I'm not aware of it. They do.
Thinking that the statute originally meant to refer to the date, not the time. So if we change this to the date when the parties or either of them appears, would that be more accurate?
It would be more accurate. We date stamp everything that comes in, and then we make any hearing that takes place. We note if somebody's not there, there's a note of it.
And does the register keep track of the date by which a party should have appeared but has not?
Oh.
No, that's just me adding 14 days or whatever, right? That I just go in and do my own date calculation.
We have a timeline. We have a little sheet in our small thing, so we put in like where the timeline should be in the case, so that we can keep track of things, and so that we know when to send out, a notice of intent to dismiss or something like that. But I don't know if that would actually qualify as being part of the register for the purposes that we're talking about here.
Yeah, that's what had me worried, is that courts may have means to keep track of it, but I'm not sure that they make a note of it in the register.
Yeah.
Yeah, except then when that form is then used and then we kick out then the notice of intent, then that becomes, of course, part of the register.
Right.
So would it work if we said the date when the parties or either of them appears, which that'll be logged, presumably, or their failure to appear as scheduled? because you would presumably note like when someone's supposed to be there, if this is talking about in person and not just paper filings.
I might prefer as required.
As required. Yeah, okay.
Because we do send out those notices and those are, I mean, that creates the obligation on the part of the party to be there as long as it's a lawful notice.
Okay. So there, the statute would only require you to include in the register failures to appear. And it wouldn't indicate that you were supposed to log in the register the default date. Would that work?
Yes, because any default that gets entered later would have its own, its judgment will be there and would have its own date. It would be in the register as on its own. Yeah.
Jim, does that answer that first question?
Yes. Second one, subsection 3 kind of ends with some words missing.
Oh.
Which section, Jim?
3. Section 3, subsection 3.
Yes, thank you.
Okay.
This is a reference to, yes, it should say, it also consists of any audio recording or stenographic or other reporting of any justice court or proceeding made pursuant to 5105 if all parties and the justice court agree. And the missing language is that the recording or transcript should be the official record of the case. That language is in 501 or in 51105. And so that language should be there. So just for everyone, 5105 allows a party to arrange for recording or transcription of a hearing. That arrangement, that recording or transcript is not the official record unless everyone, including the court, agrees. And so this would require the register to reflect, no, this would require the case file to include that recording. Is that a problem?
I don't think that's a problem. It's not going to come up very often. Number one, the one time I had it come up in the 6.5 years I've been here was a few months ago. But once the party who had brought a court reporter with them, once they found out that that meant they could not make an appeal to the circuit court, because now you have an official record, you have an official reason that, as I recall in the languages, that would then preclude the de novo review to the circuit court. Then they said they didn't. Then they decided they didn't want to do that.
Because I think you're only precluded from going to the circuit court if you're a court of record, and I think just bringing your own stenographer doesn't make you a court of record, because to be a court of record, you have to be approved by your.
There's that stipulation that then they agree to make it the official record for the proceeding.
I think you can, interestingly, I think you can have an official record of a proceeding without becoming a court of record. And that's because to be a court of record and then bypass the circuit court and go straight to the Court of Appeals, you have to have, I think, approval from like your board of county commissioners or other overseeing agency. But that's my impression.
I was a simple country judge, and maybe I was wrong about that. So
sorry.
Well, it's a moot point. It's not going to get an appeal because the party that brought the reporter wound up winning the case because it was a noise complaint, and the deputy cited an individual, an on-site manager, who he cited the next day, who was not present and didn't cite the business or the company, and who he testified that's who he intended to be the defendant. And so the citation got dismissed on a technicality.
Okay. Under 5111, sorry about that. Go ahead, Justice Kidd.
Oh, I was only going to say you just literally cannot be a court of record if you're within X number of miles of the county seat. Another weird geographic thing. So. Yeah.
Without a special exception from the, right? No, that's not the one where there's an exception. I'm thinking of something else. I apologize.
And Judge Patno?
I think there's no problem at all, including that as part of the record.
Okay.
Yeah.
And just for our sense, how often does this come up for those of you in the justice courts?
Never.
Never. Okay.
One time, 6.5.
Okay. We will make that change, have it be part of the record. Okay. So anything else on section 3 about case? Oh, Lindsay. Yes.
I just had a question more about that record. Will that be filed with the court? It just wasn't clear to me that if someone has that, makes that recording, if it goes to the justice court and is filed with them.
Good point. I think this sub 3 assumes that that has happened because it says the record includes it. But I don't know if there needs to be a corresponding change in 5105. Judge, maybe you have that open.
I do. Looking at it here.
It might be that we need to specify that if it becomes the official record, it needs to go to the justice court. Yeah.
The current is that the statute is currently written does not specifically state that. One could certainly imply that if the parties have agreed to becoming the official record, that would by implication mean that it would have to go to the court, to the justice court, but it doesn't actually say that plainly. I would suggest that we should make it say that.
I think that's a good idea. Okay, good.
And again, at the expense of the party who brought the recording device or stenographer in the first place.
Okay. And again, storage, is that a concern at all for the justice courts?
Well, could this be electronic? That's the other thing I was thinking. We have WebEx and Zoom now, and I don't know if there's a way to transfer these.
I think the court would have to agree that would be the official record. And as a practical matter, I'm not going to do that with electronic records because I can't do that for 20,000 cases.
Yeah.
The data storage costs would
Okay.
overwhelm me.
Okay, so any storage issues could be handled in a jurisdiction based on their resources. Okay.
And the statute as it's currently written does state that the parties and the court have to agree, so.
Yes. Other issues about the case record, section 3.
Justice Duncan, I don't know if this is a good time for me to share some input that we received from some of our offices, that it would be helpful somewhere to indicate that the parties should have access to a copy of the case file. We've encountered a situation, and I don't know how widespread this is, where individuals or their attorneys have been told that they need to submit a public records request and go through the whole public records process and pay for the records in order to receive the files that they need to participate in the litigation. And this might be like a one-off thing that happens, but that was communicated to me that it'd be helpful to just clarify that parties should have access and that they shouldn't be required to pay to have access.
Okay.
Well, I think there's a reasonable copy fee, especially if you want a certified copy of it. That's a fairly nominal amount. Just like anytime you go and you make a copy of a record, but it's any party can come in and get the copy that exists. I've never heard of any of a court requiring a public records request for that. Anybody else hear that?
We do charge the public records fee at my court, which ends up being about $4 for everything that's in the file. Because otherwise we have people sort of asking for them all the time, right? And the copy costs get sort of out of hand. So we do, I don't know, maybe that's not a good thing to do, but that has been our process, is to use that.
$4 is pretty cheap. I think we charge more than that for certifying the copy of the. I think we're $8 for that copy, and it's 25 cents a page.
Heather, can I ask a clarifying question? Are you talking about like getting just being able to look at whatever the file is, or having a copy made?
Having a copy made. And I think from our perspective, reasonable charges make sense. So long as there's an opportunity, if somebody is unable to pay at all, that there's a waiver.
We have an affidavit of indigency form they can fill out, and I make a ruling on.
And again, like I know practices vary so widely, and I don't mean to suggest anything about the practices of anyone who's here. Just that's an issue that some of our offices have encountered in a place that I'm not even sure where it occurred.
Well, if that happened, I don't think it should have, and I'm certainly sorry that occurred.
Other issues on the register and file? Okay. Not hearing any. Let's move to section 4. This is an existing statute. It's based on 5130. And it talks about what happens to justice court records. Says that they're supposed to be safely and securely kept by the justice court clerk. There was a phrasing issue that we encountered in the drafting. And that was one, how to refer to this person, this entity. So I think there was a suggestion for circuit courts, the person is referred to as the trial court administrator. Sometimes in the statutes, the person is referred to as the justice of the peace themselves. And then sometimes it's the court clerk for those of you in these courts. And then for those of you who have experience with kind of the language in other statutes, can we get your thoughts on how we should refer to the person who's in charge of the records of your courts?
Clerk works pretty good.
I think so too. I think that works. Clerk.
Do you have, the circuit courts have like a trial court administrator? Is there an equivalent person?
The name is different, county to county to county. So they're all a flavor of clerk.
Okay.
Yeah.
Any other thoughts just on that terminology? Okay. This highlighted section talks about when the justice court is abolished, the case records should go to the clerk of the circuit court for the county in which the justice court was located. That's the existing requirement. The question is whether the local court should turn the records over to, we have a question about whether there should be a similar requirement for municipal courts. There's not currently, I don't think. And the question is, should these records go to the circuit court or should they go to the county? Any thoughts about this?
I believe they should go to circuit court just because of my history. I think it's best it goes to another court.
That's right. Okay.
It's going to be rare, but it does happen occasionally. Where courts, there have been justice courts that have been abolished and then came back into existence. But I just think it's a cleaner trail of that important record.
And that's the court that has jurisdiction ultimately after anyway. So
yeah, because people continue to make requests sometimes on files that are quite old. And so you need a judge to be able to exercise some sort of power over it. And so if it goes to the county commission, I don't know what they would do really with that.
Yeah, although conversely, one thing which occurs to me in that arena is, you get these judgments and like in traffic violations, the judgments exist 20 years. But we constantly are having For example, we check our database and we have the collections company that we contract with to try and collect these amounts that, you know, it's illegal to collect one once it hits 20 years of age. And so you constantly have to make sure that these things are being updated and terminated once the 20-year mark has been hit. So there is this ongoing issue that somebody's got to monitor if the court gets abolished.
Okay.
And I will say that I did check with some others at OJD and no one had a recollection of this having happened before. So I don't think that it is very common. And I will take it back to others at OJD to make sure that we don't have any other kind of like just procedural issues with accepting those records if it does occur.
Okay.
Yeah, but there was a risk of it occurring. There was a vote. I mean, very recently a vote in, oh my gosh, the county just fell out of my head.
Grant.
Where there was a very close vote on whether or not to continue that justice court after the current term ends. That they decided one person, one commissioner changed their vote, and so it's going to remain in existence. But I'm just saying it's a possibility that it may happen.
Okay.
So.
And I think when we get to the municipal parallel section of this, there's going to be a different question because the justice courts are state courts, the municipal ones are not. And so what do you do when you have the municipal court records? So this might be one of the instances where there's a different answer for municipal courts when we get to that point. Section 4 is pretty short. Anything else on section 4?
Unfortunately, yes. First of all, I wonder if the first sentence should be phrased in the active voice rather than the passive voice.
Okay.
I will leave that up to Jessica whether she wishes to do that or not.
Okay.
Second thing, I'm wondering whether the third sentence, such case records are public writings, should be the second sentence, because place where it is, it kind of suggests that it's a public writing only after it's filed with the circuit court.
Yeah.
And it also may address to some extent Heather's question, because it makes clear that they aren't public writings and therefore the public has access to it.
I thought that was on purpose that it was separate, because there's some, like I occasionally make sort of judicial notes, right, as I'm deciding a case that I do not believe are subject to public records request under the deliberative process privilege, right? And so after it's a case file, I think, sure, it's fine. But while I'm in process, there are things that I don't really want to be discoverable. And so that's why I thought it was separate. Maybe I'm wrong.
Now I've become fascinated with what those writings are, Judge Kidd. I'm going to have to.
I don't like her hat. No.
So this sentence is in the current statute, and it did give me some pause. I wasn't really sure why it was there, and I wasn't sure. I think it predates. I don't think it was created in connection with like modern public records statutes. So I'm not really sure why it's here. Why it's an existing law.
Sorry. So
Go ahead.
My sense is that it's spaghetti. Right. I think that there's just these statutes have been visited so many times at different like weird times. And then the circuit court statutes like get this like systemic nice thing like we're doing now. And the ours have not. We just haven't benefited from that. And so I think there's a lot of just weird random stuff out there.
So let's maybe step back then and talk about what we think the purpose of this is and what we want to say about what we're now calling the case record. So that's just the register log and the filings. That's what we're calling the case record. What do we want to say about that along the lines of this public writing sentence, if anything?
Well, I think there's a comparable provision respecting circuit courts.
Okay.
Just to make clear, because I believe that there's been litigation in the past, whether particularly in domestic relations cases, these are open to the public, and the general response has been yes, they are, because circuit court writings are public. Circuit court records, that is the case register, and those items required to be retained in the case file are public writings. A judge has the authority to seal certain parts of the record, but unless they're sealed, I think the statutes governing circuit courts make clear that the register and the case file are public writings.
Okay.
I agree with the judge that there's an issue of whether the judge's notes are public writings. I think they are not, but I don't think this statute is intended to address that issue. This statute is limited to the case register and the documents that appear in the case file.
If that's what we're saying, then maybe the subject of the first sentence should be the case register of a justice court is to be safely kept. Because right now it says records, which is broader than that.
So maybe, because it does say records, and the term of art that we want is case record, which is in what we're defining in section 3. So maybe we delete the S and maybe we add the case record as defined by section 3. And that will make it clear that it's just the log and the actual filings. That's what we're talking about. And then we need to figure out what we're saying in the public writings. And so there might be a small research task there along the lines of what Jim is saying. What's the circuit court equivalent? Why is it there? And what does it achieve? Like, and do we want that same thing here with these records?
I like that reference, Justice. I think that's a great idea to where the case record is defined. I think that if we keep the case records are public writings, I agree with Jim. I think it should be the second sentence.
Yeah. Okay.
That's just my 2 cents. This is just grammatically in terms of the structure of the paragraph and linguistically, that's what seems to me to make the most sense and to be what's being said.
I think that's right. I think that's right.
And I think it has to stay in the plural because we're talking about the case record of all cases, not just the case record of one case.
I agree.
Yeah, so we would say that case records of a justice, case records of a justice court, and then maybe we would put the as defined in section 3. And
yeah,
and that would be where the modifier would go. Okay, so maybe we'll do a little research project on this last sentence, figure out where it came from, what it's supposed to do, and talk about how what we want to do with the Justice Court statement of public writings. All right. Anything else on 4?
Oh, I would just add that the term public writing is a pretty antiquated term. I mean, we're really talking about public records as described in chapter 192. At least I assume we are. So we should probably update that as well. And then I can help with the research project if needed.
Great, thank you.
I totally agree with you, Jessica, by the way, on that. The only question I have is if the public writings is something that's commonly used elsewhere in the ORSs, do we want to?
It's not. I just actually did a quick little search for that. There's just a few references to it.
Yeah.
Cool. All right.
It seemed antiquated, and because it's not the same terminology as in the public record statutes, I thought it made it unclear of whether it was trying to say these are public records for those purposes or not. So if it is to achieve the goal of saying they're public records for the purposes of the public records law, then we would do that explicitly if that's what we think we want to happen. Okay.
And just really quickly before we go, it seems that last sentence is qualifying the previous sentence. So when a justice court is abolished. So that's really just saying, and it seems like you could just fix it by saying, such case records remain public records.
Yeah.
So that sealed or anything like that. I don't know if this happened in the past at some point that made everybody concerned about it, but if you just say they remain open, then I think it kind of quashes any sort of concerns.
I think we'd have to decide. I don't read it as a qualifier to the previous sentence. I think regardless of whether the record, whether that record is still with the justice court or whether that justice court has been abolished and now it's in the circuit court. Those are public records. So I don't think it qualifies. I don't think it only happens once it goes to the circuit court. I think it's applicable to any scenario where that record exists.
I could agree with that. Absolutely. That's why I put the word remain in there. But if you just want to say, regardless of before or after, it's abolished, so that someone doesn't think that once it's abolished, it's no longer a public record.
And we're being super finicky here, and I get that. I would be very surprised if this were ever an appellate issue. But then again, I once had an hour-long heated discussion with Justice Gillette about what the word "a" meant in the statute, that we were both delighted to have, but the rest of the table was not at all thrilled.
See, and our work today can hopefully, reduce the need for those conversations. Okay, we are closing in on our time here. The next section is section 5, which talks about transfer to circuit court. I don't want to dive into that one in just the minutes that we have left. We have 2 meetings already on the calendar to continue this effort. I know that it's very detail oriented and it takes your time and attention. We greatly, greatly appreciate it. I hope you feel, for what we've already accomplished today, that this group is taking steps to improve the law, and it's going to make a difference. So thank you very much. Because I think the transfer issue is going to take more time than we have, that's where we'll pick up at our next meeting. Because of schedules, we won't be having our next meeting until September. So when we resume, we'll meet here and talk about section 5, and we'll just continue to go through this process. We'll continue to work through this draft, and then later on we'll pick up the civil cases and the municipal cases. Please feel free to share reach out to your colleagues, ask for input, and we'll try and write up a summary or a revised version of these sections to reflect what we've talked about today. But that's all I have for today. Krista, is there any, our next meeting is I want to say the 9th, but is that correct? I think that's correct. Anyhow, we'll resend the links and make sure you have the date of that. Anything else before we close?
I believe I have it on the 6th.
Okay. So right after, okay, good.
The one question I have is, do we have representation from a circuit court administrator? I mean, we're talking about circuit court here a lot, and I may have missed who's online here and who, but should they be part of this if they are not currently?
I will be reaching out to them. We'll definitely have an internal group reviewing it, but I'd be happy to invite a trial court administrator if that's something that the group would like, or just identify some people that might be interested if you all want to invite.
I think that would be super great, because while our job looks very fabulous from the outside, fully 30-40% of it is administrative, because a lot of what we do is high volume of small cases, right? So if we're going to do something that shifts a lot of work, the people who really going to have to do the work are the TCAs.
Mm-hmm. Maybe Judge and Justice and Julie, if there's particular administrators who you think would be really good to add to the group, and I think it would be helpful if we have them from kind of different types of courts. So maybe the needs in more eastern or rural court, especially maybe there's a Eastern Oregon County that has a whole lot of justice courts that feed into it, or a very busy, just if there's different types of court administrators, can you circle up with Lindsay, and then she can work with those court administrators? And great.
Thank you.
Anyone else who you think? Now we have some people who can be at today's meeting, but if you think, like Judge Patton did, that there's other people who need to be part of this conversation, just shoot us an email.
I find Richard Molnar to be really an effective administrator, so I would say maybe Washington County TCA, if he's available. In kind of the Portland metro area, that's who comes to mind for me.
There's no justice court in Multnomah County though, so that's they're getting might not have that same perspective, but Richard would certainly have that. I think one of the larger counties, whether it's Washington, Clackamas, Marion, Lane.
We
I don't
were
know.
pretty.
Lane doesn't have a justice court. So one of those would be good. And then I totally agree that a representative from a more rural part of the state would be really important to have as well, a voice on that.
I think Lane County started its justice court back up in Florence. Greg
That's
can.
true.
Yeah.
Oh, yeah. Apologize. That's right.
So maybe Lindsay will have you take that information and see who, maybe there's one or two TCAs who'd be good to add to the group.
Yeah, Linda in Marion County would also be a good choice because we work hand in glove we've actually worked to move cases from there over here because they were overburdened at that time. So she might have some input that might be useful.
Okay. Thank you again. That's all I have for today. We will see you again in September and be in touch by email before then.